practice competing for ascendancy when actually we need them all. So that's just an overview of some of the problems I see in the field, and I share very much your sense of the need to be more flexible in our actual practice, and not privilege one theory or one set of one type of knowledge over another.
Mm-hmm.
Practice actually decide, and the participants.
Mm-hmm. And so that's what we're finding, that in fact that one, there's the four camps currently, the narrative, evaluative, transformative, and humanistic, we call them interest-based facilitative mediation, that there's a real battle and struggle between the different schools and camps, and it's in some ways counterproductive to the point of mediation, which is ironic in a way, because here people are attempting to get along and to have people get along, and yet in the very schools of mediation, they're now carving out a bit of territory. And these may be for market reasons, like Pierre Bourdieu would say, the sociologist. I was going to ask you, Brian Polkinghorst, to speak to this too, because he has obviously a lot of experience and knowledge, and is a fellow that we could invite into the room as well. Yeah, Brian.
Hey, Brian, how are you?
Good, man.
You know, we did an EEOC study at 8,000 participants, and we did survey research and interviews, and we had all the mediators, charging parties, responding parties, legal teams, human resources, and people who were just in the room to be support to one party or the other. They all filled out surveys, and we were able to track the mediation by the number and by the mediator, and we came up with all this data, but I'll just cut to the chase. We had a hit in the Harvard Negotiation Law Journal a couple years back, and we found two things that just, it was like throwing gas on the fire, because the facilitated people, or the ones EEOC says, you will do facilitated mediation. Mm-hmm. But when you get in there, and by the way, I was telling one of my colleagues, Deborah Truitt, today, that we had 25 boxes of data. It took us almost a year to get through it. And when we crunched the data and looked at the meta-analysis with qualitative stuff, we found that the more mature, more seasoned, more experienced, more artful mediators did all sorts of things in mediation, whatever worked for the parties. And they let the parties, in a very comfortable way, kind of dictate where they wanted to go. Instead of straitjacketing procedurally what the mediator was supposed to do based on the ideology and dogma of this school of thought, they just went with the flow. They took their hands off the handlebars and said, okay. And they were very comfortable with ambiguity and uncertainty and unpredictability, because, they're there, and that's the way to learn. And good mediators make mistakes, but they don't try to make the same mistake twice. So when this thing came out, we thought, hey, people are going to love this, because this eclectic nature of what the experienced people are doing really should hammer home the art side of the school rather than the science. Science, obviously, has a great role to play. And the hate mail that we got was astounding. People from transformative, people from even the evaluative people said, how could you possibly put a piece of junk like that out? And the thing is, we had very strong statistical analysis to show that these correlations, correlation is not causation, but the more experienced, the more seasoned, and the most important thing is, it wasn't just the mediators saying this. This was the parties responding to, and we asking them, what did the mediators do to break the impasse, and what did they do to make turning points and seize on them? What did they do to help you think about the outcomes and all sorts of things? It was a 12-page survey, and they were trapped. We had a good legal team, and basically it said this: in order for you to close the case, you got to fill out the survey. So, I mean, that's the only reason why we got 12-page surveys out of 8,000 people. But the data spoke pretty well to the eclectic nature of seasoned mediators doing all sorts of things that broke the rules, so to speak. And we thought that would be one of those real good contributions to the field. But the branding people, to use your terminology in your paper, Brian, those who are out to brand things, led the charge with the pitchforks and the torches, and were really upset with us. So I might come to Alaska just to hide out, okay?
If they were upset with you, Brian, you did your job.
And that also tends to be echoed by practice, too. The practitioners tell us what you're saying, Brian. They really echo that thought, that this is an eclectic, it's an interdisciplinary practice, that not one field, for example, the legal practitioners or social workers or engineers or whatever it might be, can make a claim that's greater than other fields, that in fact all of these skills are required, and so that we need an interdisciplinary focus to support the practice of mediation and really fulfill its promise, going forward. So it is echoed by the practitioners anyway when you talk to people who are doing mediation every day. Other comments or questions? Other comments and ideas on this? All right. Let's go to our next question.
Yes. We're just a little slow here, Brian, but we have questions. Yeah.
Okay.
Sure. Okay. One of the things you speak of in here is about the theory to practice gap, and it's been a very, very interesting one in therapeutic jurisprudence, and I wonder if it has parallels in some of the other areas. What we found, you remember I spoke at the beginning about rules, procedures, and then practices or roles of lawyers and judges. Well, what's happened is that lots and lots of legal professionals, especially judges and increasingly lawyers as well, have learned something about therapeutic jurisprudence, have appreciated something about it. But the point is, I think, that this isn't simply a body of knowledge that one learns and applies. It is a body of knowledge, but it's a perspective as well that really enables those who are versed in it to contribute to it, right? And so what's really happening now is that lots and lots of judges, for example, have learned something about therapeutic jurisprudence and are now starting to do things in a different way. The problem that, as I see it, is that they are now really contributing something, but it's hit or miss on whether anyone learns about it outside of their courtroom. They are not inclined to write about something like this. If they were to do it, it would run into lots of problems of peer review and all of that by academic kind of journals or law reviews. So what you have is a very, very important part of the field now being developed by practitioners. And I learn about it on a hit or miss basis when I go to conferences and I hear panel discussions or some judge says, well, this is what I do right now. This is how I address someone, or this is how I use one of the legal provisions to extract some time to be able to get someone into a program, or this is how I address an offender in a way. We were talking earlier about the balance between offender ownership and other kinds of concerns. Well, there are people who have come up with very interesting and sophisticated techniques for doing this, but they don't necessarily think about sharing it with others or think that this is something that needs to be disseminated. So I think there's a real need for sort of converting that practice back into theory, getting a hold of it and collecting it, disseminating it. And I don't know if that exists as well in mediation and all the other restorative justice and the other perspectives, but my guess is it does.
Yes, I think that's right, that there's a real parallel there. And also that, that we need to find channels for practitioners to talk to academics and vice versa, because they often don't trust each other because of the different environments they work in. And so we really need to bridge that gap that seems to be there as well.
Can I say something?
Yes.
Oh, here we go. Where am I? There we go. There's a new book out that came out late last year. It's called Debating Restorative Justice, and two of the prominent researchers in the field give their view on the state of restorative justice in their country. So one is Chris Cunneen from Australia, and the other one is Carolyn Hoyle from England. Carolyn's much more optimistic than Chris. And in this intersection, and there's some very innovative things that are happening in England right now in the field of restorative justice. They've gone through a number of papers that are sitting within their House of Commons that are being reviewed, and there's a green paper out with a public response, and the NGOs and all the people even selling restorative justice in the UK are all very supportive, and there's a number of initiatives. So it's about reinventing their justice system as a whole. So some of the elements are quite about sentencing, but more about community engagement and youth justice issues. But so she's very optimistic. Chris Cunneen, on the other hand, is not really optimistic, because restorative justice has been rolling out there for a number of years, and it looks differently state to state. And he says the big problem is that it's still seen as this small normative theory opposed to an explanatory theory, which is quite ironic given some of the bigger, the biggest explanatory theory of restorative justice, reintegrative shaming theory, was born in Australia. So there's a bit of an irony there. But he says that really the problem is it lacks praxis, and that's sort of we get attached to our models, and we get attached to our models, and we say we do X, but we don't develop good praxis around the models. We don't engage in practice at the intersection of the process of a restorative justice conference, say, at the intersection with the process at the state. So he says it's destined to fail unless we engage in holistic praxis at every level.
Very good, thank you. Other comments or questions? Yeah.
Brian from Yukon. I'd like to, I concur with what Brenda has to say, and as well, I think the whole idea of theory to practice really speaks about accountability. And as a practitioner, how accountable am I being? And as someone who also trains other people, how do you get that across to the people that you are training, the next people coming in, that we have to be accountable?
Mm-hmm. Very good.
That A word.
All right, I wanted to also talk a little bit about the. I guess I'll sit down.
Tell me if you're going to go up or down.
I was going to open the floor up in the next question to talk about other types of ADR, other types of projects in any arena that people have been working on that may not be in the center of this set of practices, but maybe on the fringe or be a different type of practice. For example, Brian Polkinghorne in Maryland has worked on the Woodrow Wilson Bridge. And maybe, Brian, to start us off with some of those alternative practices of mediating projects when there are a lot of individuals gathered in a project, and the kinds of things, when people build bridges, people die and all this other good stuff as a matter of course. And Brian worked on the Woodrow Wilson Bridge project and dealt with the ideas of partnership and partnering and leadership. And Brian, I wonder if you could talk to that a little bit. Speak to it.
The reason I got involved in this kind of work is because the construction industry is hundreds of billions of dollars a year. Every building, every road, every bridge, every structure has to be planned, and conflicts arise, and people have different artistic and design disputes and things along those lines. And just historically speaking, very quickly, 20 years ago, it was a massive legal industry in the United States where billions of dollars were exchanged in courts due to post-construction litigation. And so one of the things that occurred while we were asleep at the wheel in the field of conflict resolution was the courts and the legislatures, and using David's terminology about regulations and policies and things along those lines, they changed. They said we have to do this better. And so the construction industry, in parallel with conflict resolution, but not talking to us, went ahead and reformed the way they did their normal business. And so the Woodrow Wilson Bridge was a 9-year project. It was $2.54 billion. It's the world's largest draw bridge. 12 lanes can go up and down in less than 90 seconds, and it set 33 world records. And the reason I got involved in this is because when I was back at Harvard during the Big Dig, for those who are familiar with it, that was a fiasco. People died. The escalation and the cost of the construction more than doubled. We're talking billions of dollars here, and it was several years late. This Woodrow Wilson Bridge project, on the other hand, had a cost inflation of only 3%. It was done on time, no one died, and received all sorts of international engineering and architecture awards. There were no lawsuits, there was no litigation, and you say, how the heck could that possibly happen? And the reason it happened is 2 years prior to even the first shovel being dug, the federal government came in and said to the state of Maryland, the District of Columbia, and Virginia, of which this bridge goes through all 3 jurisdictions, you better get your act together. And so what they did is they brought in conflict resolution people, problem-solving people, collaborative problem-solving, people who specialize in cooperative competition, because this is a private sector thing and people have to compete and bid and those sorts of things. And so we went in there and they set up a program that sat on top of the way they normally did decision making, and people were rewarded for early warning systems to be able to identify showstoppers before they occurred. And we had a couple of instances where if we hadn't caught it earlier, we would have lost up to $400,000 a day on that construction project. But we were able to identify them early, get the parties in the room. And for those of you who watch movies, you remember Apollo 13, well, where they go, Houston, we got a problem. They throw all this junk on a table. They say, you guys got to build a filter. That's what happened on a regular basis on this project. But it was just by a scale of couple magnitude, because we had 1,800 people working on the project, 3 major contracts, 54 subcontractors. And so in order to orchestrate that, we had to develop a culture and a context which rewarded problem solving. And these guys are problem solvers as it is. Engineers solve problems all the time. That's what they're good at. But they're not so good at solving people problems. They can get in there with a calculator or with a hammer and fix something. But when it comes to the human factor stuff, they're not as good as they think they are. They're very impressed with themselves, though. And that's the kind of stuff we did. The reason I submitted that paper to you, Brian, is because it's invisible to the field. If you go around the country and say, what are people doing? You can list 30 things that we do, a victim offender, we can work in the courts, all this stuff. But does anyone ever hear about the silent stuff that we have to rely on every day in and out, like in the bowels of, say, hospitals or on the design and development of bridges? And so that's the only reason why it's there, is because, Bernie Mayer, since about 1995, has said, we got to be careful about who we are and what it is we say we do, because we don't stay within the own lines that we build. And I talked to Bernie Mayer about 10 years ago, and I just said, why do we even have to have lines in the first place? So I just started walking outside the lines and saw what these people are doing. I said, this is what we're doing, or you're doing what we do. We just call it something different. And I think we should spend more time looking at people who don't do conflict resolution, who do conflict resolution.
Well, that's very good, yeah, because what we see is the real connections between, for example, what David Wexler is talking about in Puerto Rico with therapeutic jurisprudence, and the connections to ADR and to mediation. And many of these are unexplored currently, and it really is important that we start looking at and dig a lot more. And so these are very good comments, I think, to bring up.
Doesn't it have to do with also, I think, in terms of what Brian is talking about, is looking at not setting your limits, so to speak, right? Because, I think the field in itself is kind of limitless. And coming back to Brian Jarrett's paper, you're talking about branding, but when you brand a certain thing, you say, this works best and this was what I'm into, are you not then not only limiting yourself, but also limiting the field as well? And I think that's a problem.
Right. So I thought we could go to our last question, and that would be the future of TJ, the future of ADR, and the future of mediation generally. Looking forward now into the future, what comments might you have about where you see 20 years from now therapeutic jurisprudence, restorative practices, circles, conferencing, victim offender mediation, and mediation in other contexts as well? We would project our minds forward. What do you expect we will see?
That is a very small question.
Yeah. Well, it seems to me that we'll see in the other paper I wrote there on the future of mediation, it was apparent to me that there are some different forces at play in the system, and there seems to be a great deal of interest from the legal practitioners now to, in some way, I might say, co-opt the mediation business. And so there's a question of how much the legal practitioners now who see maybe it's an area of practice that could develop within law now could pull mediation and some of these other processes within the very legal system that was inadequate in the first place in some regard to deal with some of these problems. And to what extent do you think that the mediation generally will be, somewhat subsumed by or perverted by the legal system that's currently in place? I think there's a real possibility there of that happening. And so you get these forced mediation programs, court-connected mediation programs that are, really law-like processes with very little, connection to what we might have thought of as mediation separate from the court system. And so I wanted to have you think about that a little bit in terms of going forward into the future. Do you see that mediation will be, flowering and that these other processes and practices will be flowering, or do you see that there will be some forces that are at play that's pulling them in? What do you think?
Brian?
Tom, yep.
Sorry, I'm going to cut you off there. Go ahead.
Oh, I'm sorry. Thomas Homer Dixon at the University of Toronto has written about environmental scarcity and human conflict, and it raises the issue of global climate change. I notice you have a polar bear behind you, which tells me you're much too close to him. They're obviously endangered by the climate change happening above the Arctic Circle. And so in looking ahead in 20 years, I think we're going to see much more environmentally caused conflict, both or at all levels, at the interpersonal, intergroup, and international. And I think mediation and everything we've talked about in the conference can make a distinctive contribution to the more conflicted human societies and environments that I think we're facing in the future. That's sort of a meta statement. But I very much hope that we can resolve these peacefully and not let these environmental conflicts coupled with the energy crisis come to violent conclusions or violent outbreaks.
Generational war.
And so I think we have a very distinctive role to play, and part of that, I think, is to rethink how we think, which your paper touches upon, but I think we really need to redefine how we think and see ourselves as embedded human beings rather than these abstract economic units trying to maximize our utilities. I think that's a bankrupt paradigm for the social sciences. So I think our field is poised, unlike many others, to make a very distinctive contribution to the future that we'll be facing in the next 20 or 30 years.
Mm-hmm. That's very good, yeah. Other comments or questions about the field generally and the areas you're working? What do you see happening in the particular areas that you're working in? For example, we talked about funding earlier. Do you think there'll be more funding, less funding? What do you think is going to happen down the road?
At least in Puerto Rico, Carlos Romo from the University of Puerto Rico Law School, at least in our case, there's probably going to be less funding available, at least for government-sponsored programs such as drug courts, new strategic perspective. But since there's usually less funding available, I think more people would actually move to mediation and other sorts of alternative dispute resolution programs, because it's going to get more and more expensive to actually go to a court and resolve your dispute there. So I think there is a future. There's a future for all approaches, but at least for government-sponsored approaches, it's going to be harder. But individuals and NGOs can probably fill in the gap. At least that's what I think.
Mm-hmm. Brenda, did you want to chime in?
In terms of funding, I'm not overly optimistic at this time. But we're becoming more and more creative, and what's happening here in Canada is it's the local players that are stepping up. They're seeing the positive effects of some of the processes that we're involved in. So we have banks and credit unions stepping forward. Where we have a big name bank helping to roll out a new initiative here in the Greater Vancouver area, looking for support for victims of homicide. So the money is coming from more creative sources, and it's the private industry that's driving a lot of the growth and development. And that's certainly the case of that organization I mentioned in Boston, ROCA. They get substantial funding from the Kellogg's Foundation. So I want you to all to eat your Kellogg's cereal in the morning. and like the $1 million. But it depends on how philanthropy works in your country. So philanthropy works in the United States much differently than in Canada, so we need to be responsive to that. But the problem of co-opting is very real, and it really comes down to the power dynamic of the institution, whether it be a court, which has a very strong power dynamic, but we even see it playing out in schools in terms of the power dynamic. So I work with schools that have never changed their power dynamic around who's the authority that holds the most power. It's never been redistributed in any real sense, but she would say she uses all the right language, she uses all the right processes, and the kids are just scared, really scared not to do the right thing because of the power dynamics, despite the fact that they are a restorative school.
That's a good point. Hawaii, did you want to chime in anywhere here?
I guess the only comment I would have, this is Ann Smoke from Hawaii, is that here in Hawaii we're seeing, I think, an increase of the facilitative community group meetings and very well designed ones. And our facilitators, some of our top-notch facilitators are very busy. And I think that's good. I think that's a good thing, because if we have good facilitated meetings and that kind of community involvement up front when the big decisions are being made, particularly with environmental issues, which are very big in Hawaii, you have less mediation in the end. So it's a little more proactive is the way I'm looking at it. So I like to see and I like to encourage the growth of good, well-designed, facilitated meetings, and whether it's in a small community group, or an organization, whatever. I think that's good. Or in the larger scale, in the statewide programs and organizations and some of the policies that are coming into effect, I think it's good to see those kinds of meetings and that kind of community involvement. The facilitation is really important.
Okay, very good. Are there any other comments or questions?
Yeah, just a comment from Vancouver.
Okay.
So we were talking about funding a minute ago, and I, from a community standpoint, I see this being a very complex issue. The funding question is so often the central divider of different agencies as we scramble for who's going to get funding for their own sustainability and survival. And unfortunately, one of the things that means in the field of restorative justice, at least, is that we rarely have the necessary conversation about what is our common vision, what are we all a part of that we're working towards, and how does each of our individual initiatives fit into that. And so I would love, if we're talking about in the future in 20 years, I would love to see us overcome some of that protective survivalism, both in restorative justice and in the wider field of alternative dispute resolution, and work together towards vision. And I think that requires a lot of coordination on our part. I did have the opportunity to spend some months working in New Zealand, and as some of you might know, the youth justice system in New Zealand is one which is formed around principles of restorative justice, or at least it's an attempt. all young people in New Zealand who are charged with an offense or who don't deny their involvement in an offense are sent through a restorative process called family group conferencing, and that's with the exception of some very minor cases and the most extreme and violent cases. Everything in that mid-range is dealt with in this way, and that's system-wide right across the nation. Now, there are issues with that. It's government-run initiative, which some people in New Zealand push back against. And I think, for example, here in British Columbia, any type of vision along those lines towards the systematization of restorative justice would have to probably be, from my sense, more community-led and community-driven. But nevertheless, if we were able to coordinate more effectively, we might be able to create a regional or system-wide or provincial approach to the work that was still very much grounded in community and in the concerns and the aesthetic of every individual locality and not a sort of a top-down approach. So talking about the future of it, I think there's a huge amount of potential, and I think a lot of it does depend on how well we're able to work together as a field.
Very good.
Can I comment from Yukon?
Sure.
All right. I just want to say that I'm very, very hopeful that for restorative justice, when we look in Canada, how the Youth Criminal Justice Act came into play in 2001, that's huge. That's part of our criminal court. It's part of our criminal code. Now, the words restorative justice, interestingly enough, are not in the YCJA, and yet it's still mandated to provide there's principles on restorative processes and practices. I'm positive because Canada has a restorative justice consortium that is just beginning and started. Canada has the federal, provincial, territorial working group on restorative justice. So I see that we are moving forward. In the Yukon, things started in the 80s. We were very lucky to have Judge Barry Stewart and Judge Haino Lillis working with us and promoting and encouraging restorative justice. But since, funding first started here in about 1994, 96 to today, 25 years later, we've grown leaps and bounds. So and even things like the small claims court in the Yukon now, if you have a small claims matter, you must do a pre-trial conference before the matter even goes to small claims court to see if it can be mediated prior to getting to that next level. So I'm actually very hopeful that 20 years from now, we're all going to be sitting back, we'll be looking at you guys, and you'll be looking at us going, yeah, you know what, we did it, right on. And just a note to Marilyn, if you're planning to go to Fairbanks, you got to come to the Yukon. So stop by. That's it.
That's very good. Are there any other comments before we wrap up? Are there any things that were unstated, somebody would like to state about any previous topic or anything about this topic generally? And we'll wrap up. If there are no further comments, we'll wrap up. But if there's anything somebody wants to say, sure, here's your chance.
Put you back on.
Brian?
Again.
Brian? Can you hear me? I'm sorry, can you hear me?
Yeah.
Oh, okay. Wasn't sure.
You're still on. Push it again. He's talking. No, because we don't hear him.
Okay. So, Tom, are you speaking from Maryland? Do you want to say a word or two?
Thank you.
Yeah, we can't hear Tom. Okay.
Can't hear you.
Oh, I'd like to thank you very, very much.
I can't hear this bit. Thank you. Somebody else has
Yeah. He's asking you.
Sorry, Tom, did you want to speak again there?
Okay, can you hear me?
Yeah, we can. Yeah. Oh, no.
Okay, he's talking.
In out. Okay, well, let's wrap up the symposium. Thank you to all, and we'll see you Thank you. Yeah, thank you.
Well done, Brian.
Thanks, Brian.
Thanks.
Brian, you did a terrific job. Terrific job.
I think he's talking to you, but.
We did okay.